Thank you very much for joining me in for another episode of Voice of Job Seekers podcast. My name is Mark, and if you have any questions about me, what I do, you can go to thevoiceofjobseekers.com. Today I have a special guest, my friend who's been a guest several times before in the past few years, past 5 years, I think. Spiegel Law. Fortunate to run across him one day on Twitter, had great conversations, and he's been nice enough to even have me on his podcast and
Right, a number of times.
different projects, right? And a couple of outside projects, which have been really cool. So I want to get right down to it because we're talking about the non-compliance agreements, but incomplete agreements. My friend Jack Kelly is often with me sometimes, and he deals with clients. Sometimes I see those words interchange. But
Sure, of course.
we're talking about non-compete agreements, and this is so relative to my platform, the people I serve, and people that Tom served, because a lot of people sign them. And if I'm not mistaken, about 1 out of 5 workers in the U.S. have signed off in some kind of way, some kind of non-compete agreement. So that's a good piece of the real estate of workforce, isn't it, Tom?
Yeah, absolutely. That's about right.
Yeah. Yeah. So first of all, I'm trying to figure out which way I'm going to answer these questions. I'm going to probably do it in reverse order, the way I wrote it down in my outline, not particularly how I have it here. But for the most part, what will it mean to American workers as far as we're talking about employees and people who are prospectively integrating with companies that may have.
I think it will, for employees, will be hugely beneficial. There's really not much upside for an employee signing a non-compete. Understand, particularly at the beginning of an employment arrangement, you're signing all kinds of stuff, right? It's like when you're buying property, you're signing all kinds of stuff, and you don't often read the fine print. So a lot of people sign it understanding that it is there, and they don't have much of bargaining power, because a lot of times the employers, if you don't sign, you don't get the job. So a lot of people sign these non-compete agreements, which of course can prevent them from working in a similar industry, in a similar job for a certain geographic region and for a certain amount of time. And that doesn't do anything for the employee. It provides for the employee, maybe the employer, but for the employee, there's very little upside for having them. So I think, and as you well know, it can be in many instances a real impediment if you're leaving the job to try to find another one. And so I think it will be hugely beneficial to employees not to have non-compete agreements.
And just to add a little bit more context to it, because that is being looked at as being banned or regulated. Maybe you might be able to help us with the way we should all look at it. Are they looking to ban the agreement, or they're looking to regulate it and give it stipulation?
Yeah, they won't ban them completely. I think that the proposals that are out there there are some instances where bargaining power is equal, where you might want non-competes, you're forming a partnership with someone, or it's some sort of business arrangement, kind of the traditional employee-employer, where the employee often doesn't have a lot of choice finding them. So they won't be off the table completely, but it'll limit in the employer-employee context for where we see them most often. If the Federal Trade Communication Commission, that is, has a proposed regulation to limit them severely. And there are some proposals in Congress, none of which have passed yet, that have similar provisions. So it wouldn't eliminate them completely, but it would greatly restrict them. So for most people that have a non-compete, it would get rid of them. It would disallow. They would not be enforced.
And you can correct me if I'm wrong, and it's been a long time since I've been in the regular working world workforce, but people found out the last minute that they were confronted with this piece of paper saying you have to sign this in order to do it. It's more or less, you walked all the way to the pearly gates without any obstruction. Oh, you've got to sign this to get in. It's so attractive, so great. But all you have to do is just sign without realizing the repercussions should you go against it afterward, leaving there. So could there be more transparency required by the companies to say that we require you to sign a non-compete before applying for a job?
Of course, this could pass those kind of laws. State non-competes are usually creatures of state law because they're contracts. Say that the federal government doesn't have some purview over them. Clearly, the FTC thinks that it does. But yeah, they could pass some kind of notice provision. Hey, just like you said, like before we get all the way down to let's start at the beginning and say,
Right.
like, maybe even in the job act, if you're going to apply for this job, here's a notice that you're going to have to sign a non-compete. I think that's usually beneficial to employees because as you said, like it gets you're about to sign the yes agreement, and then they put that non-compete in front of you. And a lot of people, right? We
Mhm.
don't assume the worst when we're coming into an new employer. We're like,
Mhm.
hey, it's gonna be fine. I'm gonna be here for a long time. And you're
Right.
not paying attention to it, and you sign those rights away. So I think it would be a great idea. And they could do that if they wanted to.
Right. Now, in the past as well, I think a lot of the people I was debating whether I want to go through how they have evolved, and that's probably we're past that point, particularly now, since we're looking at it in the face and the potential of it being altered slightly. In the past, how have people, other than not reading the agreement, how people have misread or have misinterpreted the agreement to their detriment? I think that's important to have a little bit of that background as well.
Yeah, I think probably the biggest mistake is people just don't read them or they don't
Mm,
understand what the import of that literally means. You're not working this. Let's say I just make up like 50 within a 50-mile radius of this employer, you can't do whatever job, similar job it is. And I think people just don't read it. And yeah, they're written in legalese. I understand people aren't, that's not, unless that's what your training is, you're not looking at those. So I think people misunderstand that it's enforceable. There are instances courts will strike them down if they're overly broad, which is not uncommon for employers to kind of overreach a little bit and try to enforce them. But nevertheless, as long as if you sign that and as long as it's not legally overbroad, then that's enforceable by an employer. And that's, I think, the mistake that people like this is real. This has teeth.
right. And I think it's funny you mentioned about by state because I think I'm not going to mention which state that I heard this, but I was told this that by a friend who actually walked out on a job very boldly, very vocally. They all signed agreements, but he said, yeah, this is impossible for them to enforce. And some companies have overreached the borders as far as what clauses they want in a non-compete agreement. I think that's where people, and I think that's why you kind of have both political sides, one of the few things that actually agree on, and at least in a small amount of people, that, that it's unfair that people can write anything they want and then enforce it and make it legally binding without having it restricted. So in other words, this person was able to walk out because he said that this is impossible for them to enforce. Very few people can come to that conclusion unless you have a law degree or unless you really have some insight into what a company can or cannot do. Will it take or should it have taken a lawyer to really read what's there and for that person to make a very educated decision on what they should do with their future?
Yeah, no, I think it's a fair point. There are very few people who have the training to be able to read those and understand what's enforceable and what's not, because you can't tell unless the state's law where, this is they intend to enforce this, even for a well-educated, smart person like I know as your audience is filled with, you're not going to know. Like you're just going to read the plain language of the agreement, unless you like the state court opinions that say, hey, it's unenforceable under these circumstances. You're going to have there's no way for you to know. And it's a fairly specialized area of law, right? Very few people are going to be up on their state courts decisions about enforcing non-competes, unlike your friend fortunately had that in. And you mentioned the evolution of it. I think one point is non-competes have gotten a lot more common, right? It used to be that non-competes are for where they really matter, like higher level jobs where somebody has specialized knowledge where, hey, if you leave the company, you really could damage or you could hurt the company's business by going to a competitor. And over the
Hmm.
past, I'd say 10 years or so, they're just like handing them out like candy, even for wait staff and people who are on the front line at restaurants. And people like, just come on, do you really care if your line cook leaves this job and goes, is really going to damage your business if he goes down the street and he's a line cook for another restaurant? But
Right.
you've seen employers just like, again, like it's a candy store, just handing them out, the non-compete. And it could have a real chilling effect, right? Even if they're not enforceable, like I said, unless you know that, or you're working with a lawyer, or you are a lawyer, or you just happen to know that specialized area of law. You read it, you think, hey, I can't apply for this job. I got to go somewhere else or do something else.
Right. Right. Yeah. Well, those are good questions. And I think these are things coming up. I know I promised to keep it short with you because you've got to go. but I want to be sure that I mention your website, spiegellaw.com. It's there on the ticker. People will want to look at the articles, the many articles. And of course, you have the YouTube channels where
Yes.
there's plenty of resources there. Is there anything that you wanted to add before we take off here?
I think to understand that the FTC's proposal, like it's just a proposed regulation right now. So it's not the non-competes having been banned. And I think there's a decent chance that I know it will be challenged. Like the FTC, they've got the conference where they call notice and comment, where they say, "Hey, here's the rule." People are submitting comments, and
Mhm.
then they will draft. Then they'll the rule will go into effect or can go into effect. Then it will be challenged in court. Chamber of Commerce, like a number of these other groups, have indicated they're going to challenge it. And my guess is, with our conservative Supreme Court, which isn't it's not a big fan of broad regulatory approaches, is probably going to invalidate this. We'll see.
Yeah.
But there are, like I said, there are a number of bills in Congress that aim to do the same thing. And if those pass, it would be a different story. And there's some states that disallow, I believe California, that disallow non-competes except in specific instances. So it's important to keep in the back of your mind if you're an employee, but for now, they're still enforceable. And I would just say also, if you have a non-compete that you're worried about, you can always schedule an hour consult with a lawyer. You don't have to hire them and put them on retainer. Just get a sense, because they'll tell you, and the lawyer that does what I do in your state will be able to say, hey, this is how courts tend to approach non-competes. And the final thing I'll say is non-competes are only as enforceable as the company is willing to enforce them. Just because it's
Mhm.
written on a piece of paper doesn't mean the employer is going to come after you. I don't think that means you need to be cavalier about it, because sometimes they will. But again, these companies that are handing them out like candy, like it, because it costs the company money to
Right.
enforce. They got to hire their lawyers. They got to go to court, and then they risk having a judge saying, "Hey, this isn't enforceable for anybody." Not as if just because it's on the page, this can prevent you from working somewhere else. So I would say if you've got one, you can always look, you can always ask the company. A lot of times they don't, a lot of times the companies, it's just boilerplate. It's just something they put in the agreement. They don't even care that you gotten fired or laid off or you resigned. And, uh, many times the companies be like, that's fine. We're not going to enforce that. Or they may agree to waive it so you can go work somewhere else. Cause the truth is it was just something that they threw in there because their lawyer recommended it.
Right.
And 9 out of 10, they don't really care that much. So that is another option. If you consulted a lawyer and said, yeah, this might be enforceable, then just go back to your employer and say, hey, look, this is what I'm looking at. This is the job that I want. This is getting in my way. Or would you guys be willing to waive this? And a lot of times the answer will be yes. And then you're
Mhm. Oh, yeah, that's great ad. Thank you very much. Also, you can confirm with me if I remember correctly from my American Bar Association days. Once upon a time, certain state bars would have a certain time period every month, like the Illinois State Bar used to have every third Saturday. You can go into it, or maybe they might have it online where you can get a free consultation or some kind of pro bono session. Do some state bars still do that?
oh, okay, you can check
Okay. Okay,
state
good.
bar or your county bar. Sometimes the
Okay.
county bar, like where I am, like the DC bar is very active. Fairfax County in Virginia is very active. And they'll have, like, you're exactly right. They'll have pro bono days. They'll have days where you can go and get a consultation. And also websites now. The only one I can think of off the top of my head is Avo, but I believe if you go to
Mhm.
avo.com, I think they have like a it's not, you can go there and post questions and get them answered for free. Uh, yeah, which, or at least they used to, which is really helpful. If you want a specific answer to your question, I believe they will hook you up with a lawyer with and it's a pretty, when you can have a
Mhm.
consultation with that lawyer right there. Again, I know the Fairfax Bar does the same thing, and I don't want to quote the price, but it's pretty low to get that initial consultation, a lawyer. And again, state bars and county vary. Your county bar may not have anything. There's not much you can do about that. But some of them may have either free or very low cost consultations. And again, a lawyer does this work. It's not going to take them more than an hour, sometimes less than an hour, to look at the agreement, because most of them are pretty short, and say, hey, this is how Virginia courts tend to look at them, or this is how California courts tend to look at them, or whatever the case may be. So it's worth the no or low cost to have somebody look at that if you think it's going to keep you from getting your dream job.
Thank you very much, Tom. This is very helpful. It's going to be helpful to a lot of folks. And to the rest of you, thank you very much for joining us on the Voice of Job Seekers podcast. And if you have any questions, feel free to contact me, Mark, at thevoiceofjobseekers.com. Thank you very much.
Thank
Peace
you.
and the value of love. Have a good day.